Great. Hi, everybody. So I'm Angie McGowan. I'm a senior director here at the American Public Health Association, and I'm the director of the Alliance for the Public's Health. We are so pleased to have you here with us today virtually, and are really looking forward to a discussion. What happens when your policy goes to court? A litigation Ask Me Anything with Public Health Law Watch. And are really, glad to have a chance today. Linda's going to tell us more about it, but then are really hoping to have a chance to ask questions and learn from you all. Just to get going, we will feel free to use the Q&A feature. And also, if you're watching this virtually, feel free to email us at alliance@apha.org, and we will talk with Linda and others and help us figure out answers to the questions and follow up with you later. So we are really fortunate that we have Linda here with us. Linda Teverdi is the Senior Legal Program Manager for Public Health Law Watch at Northeastern Center for Public Health Policy and Law. She attended George Washington University Law School and started her career as a civil litigator. She represented clients in matters from simple contract disputes to class actions and multi-district litigation. She also earned a PhD in 2013 in U.S. legal history, which is very cool, and she made us clear that it's not in public health, but certainly something very relevant to this discussion. And her focus was the legal and intellectual history of Reconstruction. And since then, she's become a champion for legal and health tech for social good. And we're so glad that she's working now at Public Health Law Watch and here today to provide some information about litigation to us. One thing we like to do at APHA is to give a land acknowledgement. So I will start just saying we're gathered here virtually today here in DC on the traditional land of the First Peoples of the District of Columbia, the Piscataway, who inhabited the region between the Potomac and the Anacostia rivers. They were the original inhabitants for thousands of years. We honor their history and recognize we're occupying their stolen land. And we would recommend to all of you that you consider paying land tax to the Native people on the land that you're occupying. So this webinar is the first webinar of a two-part series. This one is here virtually to give some information on litigation, to think about questions you may have and think about how we could help to answer them. There will be a second version of this, which will happen at our annual meeting at APHA in Minneapolis later in October. So anything that you all get today or virtually as you're watching it, feel free to kind of capture questions or things you'd still like to know more about. And we really look forward to bringing it. We know we're talking to a lot of our affiliate partners now, but we'll bring that to a larger APHA audience in October, and know that we'll learn some great lessons from this discussion with all of you all that we can share there. I also wanted to take a minute to thank Abby Otterson and Raya Griffiths for pulling this together from our team. I know they've spent a lot of time and been able to engage with Linda and others, and I think we have a great discussion today. So thanks to them. So I will let you all know, of course, use the chat feature, ask questions using the Q&A or the chat, raise your hand. Linda has agreed that if there are specific questions we have, we can stop as we're going along. I will use the moderator's prerogative to let us answer questions kind of squarely on the slides or the topic we're talking about. And if it's something a little broader, I may ask you to save it for once the presentation is done so we can discuss that. With that, I will hand it over to Linda to start telling us a little bit more about litigation and how it's relevant to the work we do in public health and protecting our states and, all of us to be able to do the public health work we need to. Thanks, Linda.
Thank you, Angie, and thank you, Raya and Abby. You're just so supportive in helping me put this together. I really appreciate it. And I thank everybody who's out there for joining us. So I do sort of feel like we all have a sense of urgency about what is going on in the courts and what it means for public health. And I will get to that, but I would like to start with some basics just to sort of relocate where the judiciary and the court system fits within the branches of government that we usually think of as where policy goes to, gets created and articulated. So I want to kind of situate the judiciary and courts back in with the three branches of government. So My purpose with this is to sort of, again, like I said, to sort of relocate the judicial branch within the separation of powers and checks and balances, and kind of, get to the point of what does all this have to do with Chevron? Um, but then I'm going to zero in on the courts, and I will talk about how the courts specifically operate within that system of checks and balances. And that's going to lead us to a discussion of what's changed and what's different about policy advocacy that goes on in the courts, and then what we can do to get better at protecting and advocating for good policy choices in a litigation environment. So next slide, please. So, actually, oh, I'm sorry. No, if you go back one, Abby. Uh, actually, oh, perfect. Sorry. So 3 branches of government, straight from the headlines of the Constitution. Articles 1, 2, 3 establish each of the 3 branches of government. Next slide. Legislature, it's responsible for a lot of this is review, I understand. They pass laws. Congress passes laws. The laws express policy objectives and talk a little bit about how those policy objectives should be carried out, especially with respect to complicated policy programs. Congress will create an agency within the statute, within the law, and then will delegate authority and responsibility for that agency to carry out the details and specifics of that law that contains the policy. And then, next slide. The agency then moves to the executive, in that it exists under the executive, which is responsible for enforcing and executing on all of the laws. Some of the laws, the executive oversees it sort of directly, the Department of Justice, for example, but with respect to agencies, they sort of, administer and oversee a lot of all of the agency action. The executive can issue executive orders as well, and those have the force of law. But generally speaking, what we're looking at is the day-to-day operation of the policy as expressed and further refined by the agencies. So next slide. Then we come to the judiciary. In the Constitution, I sort of wanted to point this out. There's a really sparse description of the power of the court. It's just that there's going to be judicial power in one Supreme Court, and then Congress is responsible for creating all of the other courts. This is part of my tangent into judicial history, but it actually matters. The Constitution doesn't say how many justices there should be. It doesn't talk about the qualifications of the justices. You don't even have to be a lawyer. It's a pretty sparse description of the judicial power. But one thing that is in the Constitution that's important, and I'll get back to it later, is this idea that the judiciary hears cases or controversies. So next slide. Separation of powers. Each of these branches of government, there are rules, some of which are in the Constitution that help them stay in their lane. They are separate but equal, co-equal branches of government. And so that's the concept of that they're supposed to stay in their lane. Again, some of the requirements are in the Constitution, but most of them have actually been hammered out over the course of, a couple hundred years.
Linda, can I stop and ask you a question?
Yes, please.
So I know this is talking about kind of our high-level federal system. Does the same kind of separation of powers play out at the state or local level?
Yes, that's actually a great question. Your results will differ somewhat among the 50 states, but really they are structured very similarly with the 3 branches and I'm from Nebraska, so there's a unicameral in the legislature. No, it's just all senators, no congressmen, but by and large, it's the same structure and similar sorts of, the legislature delegates authority to agencies. Those agencies are administered and run by the executive branch, very similar. So I'll be referring to the federal government, but it does sort of replicate itself in each of the 50 states as well.
Great, thanks so much.
Sure. So, again, separation of powers, checks and balances, and not a lot of specific rules in the Constitution. A lot of the kind of ways that these branches of government stay out of each other's way and don't pull power toward themselves. Those kinds of rules have been kind of worked out over 2 centuries plus. One example that has been in the news lately is this concept of is the Code of Judicial Ethics. So the lower courts, all the courts below the Supreme Court, have had a code of judicial ethics for a long time. Congress created the lower courts through statute, through several statutes, and also created a code of ethics that is enacted into law. But the Supreme Court didn't apply to the Supreme Court. So what about the Supreme Court? Well, you may have heard recently that the Supreme Court enacted its own code of judicial ethics, but that line of can Congress impose one on the Supreme Court what is kind of a fuzzy area of separation of powers that hasn't really been worked out just yet. It's unclear exactly where that line is. So that sort of process has been taking place over a long period of time. But I do want to re-emphasize that the cases or controversies is in the Constitution. So next slide, please. So we talked a little bit about, checks and balances. Again, some of them are in the actual text of the Constitution, but most are not. So we can go on. I mean, I don't think we want to get too deep into the separation of powers just yet, because we're going to talk about that in the context of Supreme Court decisions. There's also this layer of federalism. So the 3 branches of government and some of those rules, separation of powers, checks and balances, all talk about the relationship among those 3 branches of the federal government. Federalism, on the other hand, is about the relationship of the federal government to the states. I know you've all heard this before, that the federal government is a government of limited government, but limited compared to what? So limited, it means in this context, is compared to what a sovereign government is allowed to do. A sovereign is just like any sort of independent, a nation state, a kingdom. It's all of the authority and power that the entity that runs that sovereign has to tell its people what to do and to govern for the welfare. So the federal government's power is limited in that sense. The states had that full sovereign power, and they gave some to the federal government and kept all the rest of it to themselves. So the federal government is limited to the things that are listed in the Constitution. That limiting notion is real. The federal government cannot just enact legislation for the benefit of the people of the United States. The legislation, even if the policy behind it is to benefit people in the United States, still has to come from one of the enumerated powers, which is another sort of schoolhouse rock phrase that we've all heard, but may not have thought about in how it works on the ground. So so while the federal government now is, it's limited, it has a limited grant, limited powers, but it's got this kind of, it's got the supremacy clause, which means that where it does have power, it preempts the states. It trumps the states, for lack of a better term. States have to either stay out or limit their activity according to the way that the federal government tells them to in that space. Preemption, I just want to point out here that preemption vis-a-vis the federal government versus state governments is it's a different kind of thing from the way that state level um, uh, state level government can preempt local government. It's a different process, and it works a little bit differently. In this case, the federal government has to have the specific power to act, and then the states just have to stay out of it or only limit their activity to what the federal government says is a-okay. The next slide, please. So, I want to now turn to sort of specifically how things work in the courts, how the judiciary stays in its lane, what its job is. I mentioned before that courts decide cases or controversies, and I want to talk about that in a little bit of detail because it is important, because it speaks to how policy enters the chat in litigation, which is a very different thing from the way policy is debated and contested in legislatures or rulemaking processes. So the first aspect of the cases or controversies is that it limits the court's ability to speculate or opine or wax philosophical about what the law means. The courts get to say what the law means in a specific factual situation involving real people with real stakes with a potential for real harm. Um, uh, so it also means so like that limits them from just like going off and saying what the law is in the abstract. But the conversation and the discourse over policy that takes place in the courts is also limited by the fact that the courts are really only applying a slice of the law, the slice of the law that's at issue in that case, and that the parties have raised. And the discussion is limited. The discussion doesn't even get to that far unless the parties have checked some boxes in their claims that get them there and make sure that they're in the right place, that the court is the right place for this dispute to get resolved, and the things like, can the court actually even give the kind of relief that the parties are asking for? So let me give you an example of what I'm talking about. Quick example. If I say this person over here behaved monstrously toward me and I deserve an apology, courts can't do anything about that. That is not going to be a conversation that takes place in the courts. If I say, on the other hand, exact same behavior, and I fit it into the categories that courts can do something about, it would sound like this. This person intentionally inflicted emotional distress on me. That made me lose income from work. And I want that person to pay me the value of that lost work. You have to put the policy discussion in those boxes to make it something that courts will hear. But make no mistake, policy is at issue in those in resolving those kinds of claims.
Can I stop you just real quick
Yes.
there? Two
Sure.
things. One is you mentioned someone intentionally inflicted emotional distress on you. Is that enough to bring the case, or did it have to have that second part that you mentioned, which caused me to lose funding at work? There has to be something that they can
Yes.
recompense or do something to, right?
Yeah, I mean, that's a great question. Virtually any time you are bringing a civil case as opposed to a criminal case, there has to be some kind of damage involved, yeah, some harm to you that is not just harm to you, but also something the courts can do something about. Generally speaking, that's going to be one of two things. It's going to be money damages for something you were caused some kind of economic harm or some kind of harm that can be set to rights with a money damage award. The other possibility that's a little bit harder, but not uncommon at all, is the court, you may be able to ask the court for that person to stop doing the thing that's hurting you, or to, in even rarer occasions, to do a thing to make your harm go away. So those are sort of three kind of categories. But
Yeah.
you have to say in your initial pleadings, the complaint, what it is that you're looking for. And then it also has to be something that is legit to ask for.
Right, so within the purview of what the court can do, which is great. The
Yeah.
second thing is just earlier, and I know this is a little more complicated legal question, but you mentioned it has to be a person that comes to the court.
Yes.
Do you define when you say person? Are we just talking about you and me? Or are you talking about, could it be an organization? Could it be, what kind of would count as a person, or who could come to a court?
Yeah, so that can get really complicated, but of course, corporations are legal persons, nonprofit, whether they're nonprofit, for-profit, government entities can sue. So when a person is not quite, does not quite capture the whole, universe of entities that can sue in court, but and that also includes sort of associations of people. That's I just read recently, Justice Thomas would prefer that associations not be able to have standing to be able to bring lawsuits, but even associations of people. So if you're members of the association are suffering a particular kind of harm, or are affected by legislation or a policy, the association as the plaintiff can come in representing that group of people.
That's great. I just know that's one where the term we use legally is often not how people would interpret person. To follow up on that, Mackenzie asked, when did corporations become legal people? And have they always been defined that way? And Ryan mentioned Citizen United, which is part of it, but I think they've kind of led
So
up.
yeah, so Citizens United actually, corporations were people before, were legal persons before Citizens United, but Raya's point is really well taken, that in Citizens United, the Supreme Court decided that as legal persons, corporations have First Amendment rights and are able to make political donations as part of their First Amendment expression. I would love to go into the history of how corporations became people, but it is beyond the scope of this discussion. It I will say this because it's kind of fun. It came in a footnote in a case. The name of the case is Caroline Products. That's what it is.
Nice. Okay.
I win the quiz. Yeah, it was a Supreme Court decision that made corporations into people with persons with legal persons with legal rights. Let me just do a little bit of a tangent that is relevant to reproductive rights, and that is this concept of fetal personhood. In the same way that the court was able to confer legal personhood on corporations, it is not it is not beyond imagination that the court could interpret the law, the Constitution, to include fetuses as legal persons. So, good question. Feel like it was a worthwhile little side trip.
That is, I think, very relevant these days. So thank you. Okay, sorry. Just thought those were a couple good things to ask, and thanks to
Yeah.
Mackenzie and others for asking some questions too.
No, please, by all means, I will just motor through, and I really appreciate the questions. I'd really rather answer questions, and so no need to apologize for jumping in. Just the standing, following my presentation, standing is an issue that came up recently in the Mifepristone case. We can talk about that a little bit later. I loved the sort of pithy way that Justice Scalia described standing, and it's, what's it to you? Why do you care? How does this, you can't be a bystander. It has to be, you really have to have direct stakes in the outcome of the litigation. And there's tomes and treatises and books written about like what standing is and when it's there. But again, if you're talking about it in the context of specific parties, that's how you sort of flesh out what standing is, the abstract concept, into real, down to the nitty gritty. Jurisdiction is, I riffed on Scalia, and what's it to this court? Why does this court have the power to hear this? And then there are prudential concerns. That's a big category of things that are, what's it to the courts as a whole, as opposed to, shouldn't this be something that one of the political branches decides? And other prudential concerns can be things like, well, this isn't ripe yet. It's not yet a case or controversy. It's just something you're afraid will become one. Not ready yet. On the flip side of that is mootness. And we're seeing a lot of mootness arguments with respect to objections to emergency measures. A case that's moot is one that's done. The harm, like whatever happened, the courts can't go back in time and fix it, and there's nothing that they can do going forward. So it's not a live dispute anymore. And again, that takes it out of the case or controversy category. Again, I'm seeing lots and lots of vaccine mandate cases that are moot. So they just go away. They get dismissed. Any questions on that?
We did
I
have
have a
one
question.
question. Oh, go ahead, Brian.
Yeah, I had a question about standing. Do you have to have standing to file an amicus brief?
No. Oh gosh, that's such a great question. I don't think so. I mean, an amicus brief is a friend of the court brief. I do think you have to file a sort of pro forma for permission, but honestly, I've lost the quiz now, because that is actually something procedurally that I should know a little off the top of my head, but I don't. But you do not have to have standing in the way that that the parties do by any means at all. I think the permission to file for amicus, the permission to file an amicus brief is, the bar is extremely low. So, anything else about that? All right, so let's talk about court hierarchy. Very exciting. Basic court hierarchy, the two federal courts go up one ladder and state courts go up another ladder. They are very similarly structured in that the lowest court is your trial court, and each level of up this rung is an appellate court. As you go up each of these rungs, the issues that the courts can and will decide become narrower, until hopefully when you're at the Supreme Court, the issues are really well defined and specific. There is interplay between federal and state courts, but it's very in the weeds. Generally speaking, what you're looking at is these are kind of two separate hierarchies. But that kind of also brings us to how does precedent and stare decisis and all of those, I'm sure we've heard a lot about that in the news lately. The way the hierarchy works is that each higher court, starting with the trial courts, that first court, the higher courts bind the court below them with respect to the case, a specific case that's being decided. So a higher court to me is I am bound by their decisions. I don't have wiggle room. With respect to precedent, that isn't in my case, but is in a very similar case that happened, at another time, that's where stare decisis comes in. Something that's precedent means that a case that was, you want cases that are similarly situated to be similarly decided. That is not just about predictability and being able to know how the law is going to apply even before you get to court, because you've seen how the courts apply it to similar cases. It's also about fairness, because if the law applies differently to the same situation, then fairness might be lacking. So precedent is important in making sure that like is treated the same as like. Stare decisis comes into play when there's a lot of precedent or a long-standing precedent, a lot of similar precedent, a lot of courts saying the same thing, or a lot of courts or one rung on the ladder saying the same thing for a long time, expressing an interpretation of the law that has been around a long time. The concept of stare decisis is you just don't undo that law unless something has really changed on the ground, or in that would make, or something, or things have changed so much that it makes the precedent obsolete. Again, it's not a hard and fast concept. It never has been, but it is a really powerful guideline for courts. So again, to make sure that things are fair, and to make sure that people understand what the law is, not just on the books, but when they go into court, it's going to be predictable and applied equally to people in similar situations. So it's not, while it's not, there's no constitutional requirement, and it isn't a precise tool, it's still very important. So does anybody have questions about that? All right, so that's basic state and federal court hierarchy. Next slide, please. As you can see, both of the rungs of this ladder go to the Supreme Court, and the Supreme Court does have some review power over state court decisions. But generally speaking, if something is really state law, it stays in state court. And the state Supreme Court is where the case will end. It's where the precedent ends. States have the ability and the authority to interpret their own laws. And that is, and if that's what we're talking about, state laws interpreted by state courts, there has to be a reason why the Supreme Court hears it. There has to be some kind of constitutional implication, some kind of federal issue that gets it into the Supreme Court. So, Mackenzie.
So that made me think of the recent Supreme Court decision, I don't know the name, about the criminalization of homelessness in that Oregon city. Can you talk about what you like, the legal
Yes.
stuff in terms of that case, to like help walk that through?
Yeah, absolutely. I think that may even be my next slide. Abby, do you mind my?
Ooh.
Yes.
It's nice foreshadowing, Mackenzie.
Yeah. So thank you very much. Perfect question. So we've sort of been talking about, without necessarily naming it, that we're talking about, policy decisions and what happens to the policy when it goes into court, and who gets to review, and what precedent looks like, and how you make it all kind of meld together and predictable and fair. And I'm not deviating from that necessarily, but the way that individual constitutional rights affect policy is a little more, it's different and it's a little blunter. So using the grants pass example, cities have a home homelessness is a very tenacious and serious problem across the US. I'm going to sort of paraphrase myself because I wrote about this recently for our newsletter. Justice Gorsuch was writing the opinion in this case, and he was, very clear-eyed about how important this problem is and how important it is to help people, or to help with, to allow cities to deal with the homeless crisis with all the tools that are at hand. Like let's not tie their hands. So that's what cities were trying. One of the tools in their kit bag was criminalizing sleeping, camping in public. So the individual right that sort of came in to say, wait a minute, I understand this policy, I understand there's a problem, and I understand this policy is meant to address this problem, but you've gone too far. You haven't thought about some of the individual rights that are being implicated, or they're being, that you're trampling on a little bit here. And the individual right at stake in grants pass was the right to be free of cruel and unusual punishment, which falls under the 8th Amendment to the Constitution. And so the way that this works is the policy exists, the policy has harsh implications for certain people, and then those people come to court, and there's a sort of a high bar to say this complaint that I have is a constitutional right that deserves extra protection from just general, the sort of usual way that policies can sometimes hit one group harder than another, that can benefit some and maybe inconvenience others. In this case, this is a very important individual right, and this policy hits it too hard. And that's kind of how constitutional rights work versus policy. There's a high bar to showing that your right is not just an inconvenience, no matter how harsh that inconvenience would be. That's a high bar. But once you get there, there's a high level of scrutiny. That policy has to be really necessary, and it has to be important, and it has to be very, very narrowly tailored to the problem that the policy is trying to address. And I've said a lot. So I hope you have questions. I hope I've said enough to provoke questions and not confusion. So the flip side, so another case, we're going to talk about this. So in grants pass, what happened was the majority of the court decided that the plaintiffs who alleged that they were being made into criminals for just falling asleep in public, and that was criminalizing the status of being without a home, that violated their right to be free of cruel and unusual punishment. Justice Gorsuch said, no, it doesn't. It doesn't violate that because for lots of reasons, but the decision was no. Having talked about stare decisis and precedent, that Justice Sotomayor was, in her dissent, was very vocal about the fact that there was lots of precedent that was very, embedded in the law, important stare decisis, saying that criminalizing a person's status is cruel and unusual punishment. But that argument did not win the day. So let's at the next slide, I think we're talking about some of the other cases that we've implicated. And what I'll, as you can see, Grants Pass was on my list, was at the bottom of the list, but not for reason of importance, but just because I wanted to talk about sort of two sides of the individual rights argument and kind of how that affects people. So with the denial of a constitutional right to be free of this criminalization in Grants Pass, it will make it much harder for people, for anyone to object to other similar laws in the future. There's not a constitutional, this isn't cruel and unusual punishment under the 8th Amendment. So cities and municipalities are going to be pretty free to do exactly what Grants Pass did. And I'm not going to get into, I mean, I'm so tempted to get into the facts of this case because it was an outlier. But before I do that, I will talk about a case, Tandon v. Newsom, which is a free exercise case. In that case, the court did find that this right, free exercise of religion was very important, and it has long been recognized as a constitutional right that deserves special protection. And in that case, what happens to the policy? I mean, I think we all kind of have firsthand experience with what happens to the policy. It's that it starts to become very difficult to figure out how to how to create a measure that covers everybody, except that uses a scalpel to create the policy, and to sort of have the policy cover this situation, but not that situation, to give an exemption to this group, but not to this group. Because if you, according to Tandon v. Newsom, give an exception to any secular group, you have to give that same exception to people who allege that the regulation steps on their free exercise rights. So
I mean, it's just because I know for a lot of us, I think the principles you got out there with religious freedom and stuff, could you give us a little bit of the fact pattern? Because I think it's public health focused and would be helpful.
Yes, I'm going to give an example, and like I'll recommend the case that came out of the Second Circuit, called "We the Patriots" versus whoever the governor is. Actually, no, it's "We the People" versus the school departments in Connecticut. So in that case, Connecticut had been giving both medical exemptions and religious exemptions for school vaccines. So not COVID vaccines, but childhood vaccines in schools. So you could apply for a medical exemption or a religious exemption. But then the numbers of people asking for religious exemptions was going up dramatically and threatening herd immunity. So the state decided to repeal those exemptions and have the medical exemptions only. And an organization, representing people who are affected by this legislation, sued I believe it's the school board, I'm not 100% sure, and said, you can't do that, because if there's a medical exemption, there's that secular medical exemption, it's absolutely comparable. It's the same thing. You have to give religious exemptions. There's no way to distinguish a medical exemption from a religious exemption. Nobody cares if they get a childhood disease from someone with a medical exemption versus a religious exemption. It's the same thing. So you can't make a distinction. The reason I'm recommending the Second Circuit's opinion in that is because the way that the Second Circuit deals with that issue of comparability and like what's comparable and what's not is pretty masterful and encouraging. They, instead of saying it's not about, individual, the goal of public health in that case is not about it's not just about protecting individuals' health. It's about protecting population health. And if you look at the goals of this repeal of a legislation from a population perspective, medical exemptions promote that population health by protecting people who can't get vaccinated as well as people who can get vaccinated. It also supports herd immunity, et cetera, et cetera. The religious exemptions, on the other hand, do not promote health. They are about something else entirely. And in fact, they undermine health because there are so many that it threatens herd immunity. And it was really quite a masterful explanation of why a roadmap really of how to frame the public health purpose in a way that allowed the court to find that, oh yes, these things are all lined up. These things lead to the public health purpose. The religious exemption doesn't. And the Supreme Court denied cert, which meant that decision stands, and the Supreme Court's not gonna listen to it, so they can't overturn it. So anyway, sorry, that was a long discourse. But that is a real life example, and it was also, again, just a really encouraging example of one thing of why it's important to understand how the conversation around policy takes place in the context of litigation, as opposed to in a policy debate in the legislature or rulemaking process. The conversation is very limited and, for lack of a better word, stylized. It's not stylized for style, but it is very limited because the arguments and the claims and all that have to fit into predefined boxes and predefined categories in a way that just changes the way that you talk about the policy. And knowing that everybody here understands what's good and bad about vaccine mandates and school mandates. We know the policy reasons, but understanding how to frame those policy reasons in a way that works in court is really important, both for making the argument in court and for thinking about how to draft legislation that will seamlessly move into court in a way that has, kind of just by the way that it is drafted, will do better in court in the way that it gets talked about in court. Okay. Let's say, I did want, I'm doing too much talking. So if anybody has questions or wants to, I can jump into these other 3 cases and then we can have a more free form conversation if you'd like.
Yeah, that's fine. Why don't you go ahead and just kind of explain, as you did, a little bit about that pattern up front, because while we know it, perhaps I'm guessing for others, the names will start kind of blurring
Yeah,
together.
absolutely. 100%. So the mifepristone case, I actually refer to it that way because FDA versus Alliance for Hippocratic Medicine is just totally forgettable. So in this case, this was a standing case. We talked about standing, talked about groups, and the fact that associations of people, associations can represent their members who are harmed. In this case, the Supreme Court actually checked itself. It stayed in its lane in a way. It shouldn't have been a close call, but we were very happy that they did actually stay in their lane. And that was because the Alliance for Hippocratic Medicine was a group of medical professionals. My understanding, it's not in the opinion, but I've read elsewhere that some of the medical professionals were dentists. And their beef was that mifepristone, they didn't want mifepristone to get the approval, the more recent approvals around more relaxed requirements for prescribing the medication. They didn't like it and they challenged it. And Angie, you know, your question up front about, do you have to, is there something you have to be harmed in a particular way? Do you have to allege that in your complaint? Yes, you do. And in this case, they tried really hard. They tried to argue that just, you know, first of all, that they that anyone prescribing this medication just offends them. Like they don't want to have to practice medicine, essentially practice medicine in an environment where this medicine gets prescribed. Didn't fly. They tried to argue that they would be put in a position to treat emergencies that arise from someone else prescribing this medication. The court said, there are laws in place that say you doctors can't be forced to perform procedures that offend your religious beliefs or other kinds of reasonable objections, and you can prepare for that. So the hospitals already do that. For what does it look like if somebody comes in with an emergency and a doctor says, I can't do this. So that you're out on that. And then the last one was a kind of economic argument saying that their pocketbooks were affected somehow. It wasn't that somehow they would lose money in their practices by it was like if patients, believe me, it was pretty attenuated. It was if a patient has a bad reaction to this medication, resources in the medical system will be diverted to taking care of that patient, and that's going to just make less money for all of us. And the courts found that that was too speculative and wasn't even supported by evidence. It was just kind of just a sort of general allegation without any evidence in the record to back it up. So court said, no standing, which was good, because that was correct. There wasn't standing in that case. It was too attenuated.
So just to clarify, the court really didn't say anything about whether the drug itself was a good drug or whether FDA could say, like, the role of FDA in claiming that a good drug, right? It was more understanding.
Yes. And that might sound unsatisfying. It might feel like it's more satisfying for the court to say mifepristone is a good drug, and this is just on the facts, not a good claim. But we don't want courts doing that. We don't want courts making the judgment of whether mifepristone is a good drug or not. What we want is courts to make sure the procedures were followed and that there wasn't anything that was, improper in the way that the drug was approved, but we want the FDA saying whether and how it should be prescribed.
I just partly was asking that because of the next case that you might tell us about. So
yes. Yes. So Loper Bright, which overturned the Chevron case, deals with Chevron deference, all things that I will try to explain in brief. So in this case, it was decided on a different, and like from in a whole different category of decision making, a whole different bucket. So rather than being about standing, it was about separation of powers. But it still had to do with how agencies make decisions and how the court reviews those decisions. So when you have an agency, agencies have to understand the law that created them so that they can understand the policy behind it. And so they can understand what regulations are going to be the right thing to promote that policy, to get that policy going. Now, laws are, courts interpret laws for sure, But sometimes, especially with a law that is hyper technical and deals with really technical subject matters, it's a mixed question of fact and law. You can't really understand the law unless you understand the technical the technology or science or whatever behind the law. The Chevron case, which produced the Chevron deference and Chevron, was it Chevron deference, Chevron, in any event, the Chevron doctrine. That was that case was decided in 1984, and it kind of tried to create some rules about when a court gets to decide what the law says and when an agency gets to decide what the law says. And the basic rule was if a statute's just clear, not ambiguous, courts are just as capable of answering that question, what does it mean, as agencies. But where that governing statute is ambiguous, it might make sense for the agency to decide that, especially where the reason that it's ambiguous is because you need to know things like, is this particular molecule a protein or is it not? What is the concentration of particulate matter that is safe for human beings to breathe in the air? In order to answer those kinds of questions, that's not just an interpretation of the law. It also requires a deep understanding of some pretty deep expertise. So Chevron recognized that and said, law is ambiguous. If the law is unambiguous and very clear, courts are perfectly capable of interpreting it. If it's ambiguous, then agencies are better equipped to answer what does the law mean, but they have to do so in a way that's also permissible. It can't make no sense. I mean, it has to make sense. It has to kind of fit the purpose of the statute. They can't just go rogue and enact, regulations that have nothing to do with the governing statute. And they also have to, avoid other impermissible things like infringing on recognized constitutional rights. So that was the Chevron doctrine. That was Chevron deference. The courts just take a step back and say, we're out of our lane when it comes to understanding what a law means when the law is dependent on expertise. What Loper-Bright did was it said, yeah, we don't like Chevron. We don't like that case. We, if you want to read many, many pages on the history, and as a historian, it hurts me to call it history of stare decisis. Justice Gorsuch has a concurring opinion. So the court overturned the Chevron case, which means that they overturned the Chevron doctrine. And they just said, you know what? Courts decide the law. That's what courts do. And that's what we're going to do from now on. We know that sometimes sometimes expertise is helpful, and we will listen to that through evidence that the parties offer, and through amicus briefs, but we're the deciders, and that's what we're going to do. So what that means is that it means a few things, and I've heard some good news in this, believe it or not, and that the good news, I'll give it to you first, is that from administration to administration, it might be harder for like a new administration to come in with a whole new interpretation of an underlying statute. Because if the courts don't have to give deference to the experts and they just have to interpret the law, they can say, well, hey, this law said this 6 months ago before the administration turned over. It means the same thing now. I would love to see that happen in in some circumstances, and probably loath to see it in others, but it's an interesting sort of interesting perspective. But what it also means is that there are just likely to be lots and lots of challenges to specific aspects, to specific regulations within bigger policy schemes. And those specific regulations will be challenged as inconsistent with the governing law, with the statute that created the agency. And the courts are just not going to have to give any kind of weight to the agency's interpretation of what they're supposed to be doing. It's likely to produce for at least a while a wide variety of opinions in trial courts, because every judge is going to read this differently, and it's going to take a while for some kind of consensus to take place as the cases work their way up through the court system. And that hierarchy starts to like create more of a shared understanding of what the statutes mean, the governing statutes mean. So
Linda,
that
for all of us who work in public health, where agencies and the health departments, and we like to think all of us public health people are really valuable to the work that happens, or those in education or other places like that, everybody seems like all up in arms that the Chevron deference standard was, thrown out, which is unusual for the Supreme Court. They don't usually just say 40 years, we're done. So what, like, realistically, like day to day, are there things that you think will change for people, or what should people be thinking about as, as they do their regular work in environmental health or immunizations, et cetera, and need to think about, like, does this really make any change or difference for me?
Well, for policies and rules and regulations and all of that are in existence, until there's a challenge, there won't be any difference in how you work with that in your day-to-day existence. One of the things that feels uncomfortable is that the challenges will not necessarily be predictable, and they may come out of what feels like nowhere. One thing that I would one reason for having this webinar in the first place is to not fear the litigation. Litigation will happen, and will feel a lot more like a part of, as much, it's probably going to feel just about as much a part of the background of your work as legislation is right now. And you shouldn't fear the litigation any more than the legislation. It's a different conversation. Sometimes the stakes can feel a little bit higher because sometimes the decisions can be so permanent feeling. But it is another place where the conversation is taking place. When it comes to, if in the situation where a policy is challenged, I'm sort of jumping ahead a tiny bit, but at Public Health Law and the Act for Public Health Partnership, we had a convening that was already before these decisions came down, talking about how do we pool our resources, how do we get information, how do we share information, and give ourselves a heads up that these challenges are taking place, and then give ourselves time to think about what our side of the public health side of that conversation needs to look like in order to get the kind of written opinion of We the Patriots, the Second Circuit decision that I like so much about childhood vaccines. Let's get that logic and those decisions on the books. Those are good ones because they really zero in on the policy and the science in a way that I think most people can relate to and would find persuasive. So we're talking about that, right? It's all of these cases kind of hit us pretty hard. Like we've all been sort of affected, and we're all kind of like stopping and thinking about now what does planning look like, and we are in the process of doing that. And it's going to be really important because as the challenges come down, we want the arguments to be good public health arguments. And so
That's great.
sorry, that was a little preachy. Oh, you're muted.
You're on mute.
Okay, yeah, thank you. I don't think I will explain this very well, or ask this very eloquently. Can you go back one slide? Okay, go back and, oh, yes, that one. So on the asterisk,
Mhm.
state constitutions have individual rights and protections, but they only apply to residents of the state. So whenever, if if states are trying to pass laws that protect people traveling to their state, for example, to obtain like abortion care,
Mhm.
how does that work? Yeah.
Yeah, that's a great question. And it's a super complex kind of uh uh there's it's and this is honestly I'm getting over my skis by trying to answer this intelligently. There are provisions in the Constitution, the comity clause, and that's not comedy, it's comity,
Okay.
that requires one state to give full credence to another state's laws and judicial decisions. So that factors into it a little bit, but there's also privileges and immunities clause that one state has to you can't one of the privileges and immunities of citizenship is the right to just travel. So you should be able to go to another state and enjoy whatever it offers and not have your state chase after you. But that doesn't mean that states aren't going to try to criminalize leaving and coming back. So like how in theory you states should not be able to do that. They should not be able to criminalize leaving, doing something that's legal elsewhere. I mean, let's put this in the context of going to Amsterdam and enjoying the, chemical entertainment that exists there.
Mhm.
Before it was legal, most of the places here. So you could do that. It's legal. You're behaving yourself. You're not breaking any laws. And you come back to the states, your state can't then punish you or arrest you for having indulged outside of the borders of the state. That should be the end of the story. It's probably not going to be.
Sure. Thank you.
That's a great question, and you asked it quite well. I didn't cover EMTALA, but I mean, it's super important, but it also was an example of preemption, where, and it's just really the space where the preemption is taking place is emergency care for pregnant people experiencing emergencies around their pregnancy and stabilizing care. So it's just like it's a really small space that the federal government is saying, at least here, we preempt state law. States can't prevent what we've provided, can't ban what we've provided. And I put it here because of the preemption, but the court, rather than deciding the preemption issue, sent it back as it wasn't ready for, it was like one of those not exactly standing, but the prudential reasons for not hearing a case, because it's not yet a case or controversy, not done yet. Any other?
Linda, are you saying that you think that case might come up again and be decided in a different way?
Absolutely. Justice Jackson in her dissent pointed that out pretty bluntly that this isn't a victory by any means. It's just a delay. She said really clearly that this is just a question of law. It isn't, we don't need the factual record to get developed on this, because it's not going to change the fact that the law says federal law preempts. It's a very narrow slice. We're not saying you can't ban abortion altogether because of emergency services that we require. We're saying you can't ban abortion services that are stabilizing care. So yeah, it'll almost certainly come back. So.
Great. So why don't we, Linda, I know we had some, if other people have questions, definitely still please keep asking them. I know we're getting near kind of the end of our time though. So I know one thing we did want to ask you is, what can people do? I know we're going to continue to talk about this, but how can they, follow court cases and think about the role of litigation in their own state or community, et cetera? What would you recommend?
Yeah, sure. I think if you go to the next slide, I have a couple of things about, I mean, the first thing, recognize that courts are as important to policy as legislatures, and include them in your thinking and your action plans. So I hope I've convinced you. But then also states elect a lot of states elect their judges, and other states, the appointment process is more accessible. We can't go, average advocates, people cannot really influence Supreme Court justices or federal judicial nominations so easily. We all have the ability to get involved in state and local judicial elections or appointments, and even if it's just at the level of, uncovering the record of the person that is running or seeks to be made to be a judge. What's their attitude towards science? Are they willing to learn? How do they think they would handle scientific questions in their judging capacity? Just all kinds of things along that line. And that also does mean that, especially in places where judges are elected, is that voting is really important, not just in presidential elections, not just in the off-year federal elections, but every time there's an election in your voting district, it should be something you kind of prioritize. We are also, I mean, I think, litigation tracking is something that, I mean, that's kind of my bread and butter, is following what's going on in the courts. We've sort of shifted toward, rather than tracking decisions and trying to see what courts are saying, sort of last word kind of things on the law, we're moving to complaints so that we can see what people are claiming, not just what courts are saying. We would love any kind of help that if you run across a case where somebody's saying something interesting. I mean, I think once you start to, these cases start to, there are patterns to them. And once you start to see patterns, you start to be able to see that this is something that we should be thinking about, that we need to be aware of. I'm trying to create as comprehensive a database of those kinds of cases as possible. So you can just shoot me the name and the state and I'll find it, but a citation would be even better.
And Linda, just to make it clear, you're not expecting them to read the whole case and the opinion, to let you know, and you'll follow it and explain it, right?
Yeah, I mean, the most likely place that you would hear about the case is going to be a media account of it, for one reason or another. Those are great because I can go find the case. I don't, it's like, if it seems interesting, you wouldn't believe how many listservs and email lists I'm on to like scare up all these cases. You can sign up for our updates to get a sort of feel for what we're looking at and what we're tracking, and that'll help you sort of recognize things. And then, just ask us questions if you just want to understand more about how litigation and how the conversation about policy takes place in litigation and litigation environment. Please just ask. We would love to have that conversation and help. And we're figuring out, I mean, the last item here is a convening action plan. As I said, we held this convening. We are still putting together an action plan that we're going to get a lot of feedback, a lot of input on what it looks like to protect public health in the courts. And so please stay tuned for that as well.
Great. You'll go to the last slide. This will let you all see links to all of the different resources, and we're happy to share these slides too. But just want to hear from all of you all if there's anything else that you had questions about that we didn't have a chance to answer. If there are things you're seeing in your own states or localities or different listservs you're following, please let us know. And I would love to add them to the litigation tracking, and we'd all love to help figure out how they may impact the work we do. And just remember, like, we are happy to answer questions at any point and refer them to our colleagues at Act for Public Health and others. But we will also have a chance again at the APHA annual meeting in October to really sit down and talk about it. And we're hoping it will be a little bit more of an informal discussion where people can really find out, what do you do with amicus briefs and how do I get engaged, and kind of what are the laws and the issues out there. So thank you so much to Linda for that great presentation. I know I learned a lot, and there was a lot of information there, and I'm sure others did too. And as you all know, there are fonts of knowledge here that we can call on. I know we also had colleagues from Act for Public Health here, which was really helpful. And I know always good to check in with them too. So thanks to you all. Thanks to once again to Abby and Raya for helping pull this together and get all the questions and organize it. Yes. And thanks to everybody.